Well, President Jacob Zuma is expected to address his supporters in a matter of hours following a constitutional court judgment that basically sent him to prison, or intends to send him to a correctional service facility for up to 15 months for contempt of court. The court has, in the last day or so, agreed to then hear Zuma's application to have that sentence rescinded. He's also filed papers with the Pietermaritzburg High Court, where he's trying to have his arrest stayed, basically pause his arrest until the matter of trying to rescind the sentence itself has been heard. We can speak to Lawson Naidoo, Executive Secretary at CASAC, for more on this. Lawson, afternoon. So a lot of us very confused about what the various moving parts legally mean for the deadline that we were told would be from today and about 3 days for the former president to hand himself over at a correctional services facility. Does one cancel the other?
Good afternoon, Thembekile. It is quite a confused state of affairs at the moment because of the number of applications that the former president has lodged. If we deal with the issue before the Constitutional Court, firstly, Mr. Zuma has applied to the court to consider rescinding the decision, or at least part of the order that was granted last Tuesday, which has sentenced him, as you say, to 15 months in prison. Now, this is a highly unusual application. As we know, it is not possible to appeal the judgment of the Constitutional Court, being the highest court in the country. And therefore, this legal loophole that Mr. Zuma appears to have identified essentially asks the court to reconsider their decision that they may have made an error of law and overlooked an issue or a concern. It's highly unlikely that that will succeed, given the comprehensive nature of both the minority and the majority judgments in that case. So whilst the court has agreed to hear the matter on an urgent basis next Monday, I'm not convinced that it will succeed.
Would he have to seek an interdict?
Well, in my view, the application for a rescission of the order, even though that application has been or the court has agreed to hear the application, does not automatically stay the court's order. He would have to seek a specific interdict against the order sentencing him to 15 months imprisonment, which he has not done. And so, in my view, that order remains valid and binding. And if Mr. Zuma does not report to a police station today, then the other part of the court order kicks in, which is that the Minister of Police and the National Police Commissioner must take appropriate steps to deliver him to a correctional facility within 3 days. Are
you on board then, Lawson, with the school of thought that says to allow Zuma to stay home until the Constitutional Court hears his case, his application would do no harm?
Well, you know, perhaps it wouldn't do any harm, but it is because of the second application that he is seeking to make to the KZN High Court on Tuesday. Now, I haven't seen that application, and I'm not sure whether it is an application for an interdict against the order of the Constitutional Court, in which case it would be a non-starter in my view, because a High Court cannot have jurisdiction over a matter that emanates from the Constitutional Court. And a similar concern may apply even if it is an application to interdict the implementation of the committal warrant that was signed by Acting Deputy Chief Justice C.C. Kampepe the other day. In either event, I'm not sure that that a High Court has the jurisdiction to deal with the matter that has been ordered by the Constitutional Court. So it would seem to me that the orders remain valid and effective. Whether they will be acted upon is, of course, another matter altogether.
And just in terms of the Constitutional Court and what's happened here, the Zuma application mirrors pretty much the minority judgment, which raised a concern about sentencing a person to incarceration without having put them through a full trial. Did the court work itself into a corner technically, on a technicality?
I don't think they did, because, you know, a proper reading of Justice Leona Turan's dissenting or minority judgment also agreed that Mr. Zuma was guilty of contempt of court. And she actually made the point that if the Commission of Inquiry had a longer duration to run, she would have imposed a suspended prison sentence. So the issue of the imposition of a custodial sentence really both the minority and the majority judgments are in agreement. They just differed on how to implement that. So I really don't think there's anything there for Mr. Zuma to grasp onto.
There's also criticism since the court agreed, the Constitutional Court that has agreed to hear Zuma's application, some saying he's already had such leniency from the courts and even the state capture inquiry itself that perhaps the application to have his matter heard should have been declined. Would that have been unfair?
No, not at all. I think, it would probably have been very fair for them to have done so, because having looked at Mr. Zuma's affidavit that he submitted on Friday, there's really nothing new in that the court hasn't already considered. And in relation to the sentence itself, we will recall that the court, after hearing the matter in late March, wrote to Mr. Zuma because he did not appear before the court. They wrote to him asking him what his views on an appropriate sanction in the event that he was found guilty. He simply ignored the court and in a 21-page response, vilified the court, vilified the judges of the court, and now seeks to go, effectively now with his tail between his legs, seeking some sort of form of leniency from the court that he has lambasted so egregiously in the past.
What then, Lawson, of the external considerations in this matter and the perceptions of the judiciary and its movements as far as issues related to Jacob Zuma, true or false? Would that be something that is commonly, or even in this extreme circumstance, factored into which way or the approach that the court will take in dealing with the issue, especially in as far as being as fair as possible to him?
Well, I think the court has been extremely fair to Mr. Zuma, and in fact, in terms of asking him to submit an affidavit after the hearing, they've almost bent over backwards to accommodate him. He's, rebuffed all of those overtures that they've made to him. They've treated him entirely fairly. The judgment that was delivered last week was a well-reasoned legal judgment, which pointed to the exceptional nature of the facts in this case, that they were dealing with the former head of state, and his consistent failure to adhere to subpoenas from the Commission of Inquiry. But those were the exceptional facts. There was nothing in the law that was exceptional, apart from the fact that this was a contempt case being heard by the Constitutional Court as a court of first instance. But the court clearly justified the basis on which it did that. So one would not want the court to be swayed by public sentiment or political considerations. They've got to apply the law strictly and clearly, which in the judgment that the court delivered last week, they certainly upheld that standard and in fact probably raised it.
Lastly then, say mid-month when the Constitutional Court does hear this application, it decides, no, it did everything according to the book and that the former president should indeed serve this 15 months in incarceration. What would be the broader implications, do you think? Is that the final approach for Zuma? Is at the end of the road no other way to try and maneuver legally?
Well, absolutely not. It's already gone one step further than is normally permitted in terms of legal procedure, that the decision of the Constitutional Court is final and binding. The court has now taken this exceptional step to hear this rescission application. And if that is rejected, then it really is the end of the road, and Mr. Zuma will have to be committed to his 15-month prison sentence.
Lawson Naidoo, thank you very much for that.